you will become familiar with the topics listed here. Who can apply for a patent varies depending on the date the application was filed. For applications filed before September 16, 2012, a patent could only be applied for by the inventor. An inventor is considered any person who did the mental act of forming a definite and permanent idea of a complete and operable invention. As such, there could be more than one person that contributed jointly to the invention, and each would be considered an inventor and may be an applicant. For applications filed on or after September 16, 2012, 35 U.S.C. 118, as amended by the AIA, provides for assignee applicants as well as the traditional inventor applicant. However, this does not affect patentability analysis. While all inventors may be eligible to apply for a patent, employees of the USPTO are excluded from either applying or acquiring an interest in a patent unless through inheritance or bequest. This exclusion protects public confidence in the patent system by removing any perception of a conflict of interest. The right given to a patent holder is the power to exclude others from making or using the patented invention. This exclusionary right is a quid pro quo for the full disclosure of their invention to the public, so that after the patent term ends, the information is in the public domain. To ensure the information can be made available to the public, the applicant must adhere to a stringent patent application format. The patent application cannot be handwritten, it must be legible, in permanent dark ink, and provide sufficient clarity to ensure the application and later issued patent is easily reproducible. Here are the requirements for paper size, color, and orientation. While patents are printed with multiple columns, the specification in the application must have a single column of text. An application for a U.S. patent must be in English. Requirements for applications depend on whether the application is provisional or non-provisional. Applications that are examined and may result in a patent are non-provisional. Provisional applications, on the other hand, are not examined and do not result in a patent unless they are followed up with a non-provisional application. Provisionals have fewer requirements and lower filing costs than non-provisional applications. They allow the applicant to establish an early effective filing date for the later filed non-provisional patent application. Filing a provisional application also allows the term patent pending to be applied in describing and marketing the invention and in soliciting potential investors. This puts others on notice that a patent application has been filed. Note that a provisional application must be for either a utility or plant patent, not for a design patent. Most patent applications are for utility patents. Once a provisional application has been filed, applicant must follow up with a non-provisional application filing within 12 months. However, a non-provisional application that was filed more than 12 months after the filing date of the provisional application, but within 14 months after the filing of the provisional application, may have the benefit of the provisional application restored by filing a grantable petition to restore the benefit under 37 CFR 1.78. Such a petition must include a statement that the delay in filing the non-provisional application was unintentional, as well as the required petition fee. In addition, provisional applications are not examined on the merits and cannot be revived if abandoned. Now that you understand the difference between provisional and non-provisional applications, what are the requirements for each? Provisional applications do not require claims, but do require a cover sheet identifying the application as provisional. A non-provisional application must include a specification with at least one claim, an oath or declaration, and the appropriate fees. Drawings are also typically required to illustrate what the specification describes in writing. For non-provisional utility applications filed on or after December 18, 2013, Claims and drawings are not required for the application to be accorded a filing date. However, at least one claim is required before the application will be placed on an examiner's docket, and drawings are still required if necessary for an understanding of the invention. For design applications, a claim and drawings are still required for the design application to be accorded a filing date. Applications filed on or after September 16, 2012, will be forwarded for examination even if lacking the inventor's oath or declaration, provided that a compliant application data sheet is filed. A patent application may also include the elements listed on this slide. The requirements of an application data sheet, or ADS, will be covered later in this module. For non-provisional applications filed before September 16, 2012, each inventor must make an oath or declaration to indicate they believe they are the original and first inventor or inventors of the subject matter which is claimed and for which a patent is sought. For applications filed on or after September 16, 2012, the oath or declaration may be postponed until the application is otherwise in condition for allowance, provided that a signed ADS has been submitted and that the ADS identifies each inventor by his or her legal name and provides a mailing address and residence for each inventor. Some statements the AIA requires in oaths or declarations for applications filed on or after September 16, 2012, are different than statements required for applications filed prior to September 16, 2012. Also, applications filed on or after September 16, 2012 will be forwarded for examination, even if lacking the inventor's oath or declaration, provided that a compliant application data sheet is filed. Effective October 25th of 2012, you are no longer required to review the oath or declaration in original applications, regardless of whether filing date is before or after September 16, 2012. The ADS is used to provide the information on this slide. For applications filed on or after September 16, 2012, an ADS is required if there is an assignee applicant, a claim for foreign priority, or a claim for domestic benefit. Domestic benefit claims must now be set forth in the ADS. While claims for foreign priority were once accepted if present in the oath or declaration, these now must be set forth in the ADS as well. An exception applies to foreign priority claims in applications entering the national stage under 35 U.S.C. 371, if the foreign priority claim was made in the international phase. This slide details what fees are appropriate for non-provisional and provisional applications. Here are factors that affect the amount of fees due on filing a non-provisional application. Small entity status for reduced application fees can be given to a person, a small business concern as defined by the Small Business Administration, or a nonprofit organization such as a university, as long as the applicant has not transferred or is not under obligation to transfer any rights in the invention to any party that does not qualify for small entity status. Fees can be reduced even more for microentities. In addition to meeting all requirements for small entity status, qualifying for microentity status on the gross income basis requires that each inventor and applicant not be named as an inventor on more than 4 previously filed applications, not have had a gross income in the year prior to when the fees are paid exceeding the USPTO reported gross income limit, and not to have made or be obligated to make an assignment,
grant, or conveyance of a license or other ownership interest in the application to another entity that does not meet the same gross income limit. When an application is filed, a filing date is accorded, providing the filing date requirements are met. The examiner then uses this date in determining what can be used as prior art, keeping in mind any earlier effective filing date based on domestic benefit claims, and in some cases, foreign priority claims. The filing receipt gives the applicant documentation of the filing date along with an application number.
Patent applications are published generally within 18 months unless applicant requests not to publish. The request not to publish must certify that the invention has not been and will not be the subject of either an application filed in another country or an application filed under a multilateral international agreement that requires publication of applications 18 months after filing. One important advantage of publication after November 29, 2000 is that it provides applicant with the opportunity to obtain provisional rights that start from the application's publication date. This can allow applicant to collect reasonable royalty from a third party that infringes a published application claim, provided actual notice is given to the third party by applicant through, for example, a cease and desist letter, and a patent issues from the application with a substantially identical claim. Provisional applications are not published. We will now discuss each document required and common informalities you may find in each. While this slide lists all documents required in a complete non-provisional application, examination of an application focuses on the specification and drawings. Informalities include errors such as misspelled words, inconsistent terminology, and incorrect numbering of elements. It is the examiner's responsibility to identify informalities in the specification and claims. The examiner then uses Form Paragraph 7.29 to object to the disclosure and note the informalities found. Note that this is an objection that the applicant must correct rather than a rejection, which denies the patentability of the invention as claimed. This is important because if a patent is eventually granted, the specification and claims will become part of the public record. These are the requirements for the specification as stated in 35 U.S.C. 112, which will be covered in a separate module. 37 CFR 1.77 sets out the preferred arrangement of specification elements, and the examiner can use Form Paragraph 6.01 to advise applicant of the preferred layout. 37 CFR 1.72 requires applicant to provide a title that is brief but technically accurate and descriptive. A descriptive title assists the public and examiners in more quickly identifying relevant inventions when searching for prior art. Likewise, the abstract appears on the first page of a granted patent and should enable the examiners and the public to determine quickly from a cursory inspection the nature and gist of the technical disclosure of the invention. MPEP 608.01, paragraph B, provides additional guidelines for the preparation of patent abstracts. This slide lists formal requirements for the abstract's format, length, and specific words and phrases not to be included. There are specific requirements for chemical patent abstracts for compounds or compositions. Please see MPEP 608.01b for additional details. We will now cover other formal requirements for the specification. First, line spacing must either be 1.5 or double-spaced. Second, the meaning of every term used in any of the claims should be apparent from the descriptive portion of the specification with clear disclosure as to its import. This is known as proper antecedent basis. Third, while trademarks are permitted, they should be properly identified and accompanied by generic terminology.
You must review patent applications to make certain that hyperlinks and other forms of browser executable code, especially commercial site URLs, are not included in a patent application. This prevents issued patents from containing live web links. USPTO policy does not permit the USPTO to link to any commercial sites, since the USPTO exercises no control over the organization, views, or accuracy of the information contained on these outside sites. We will now discuss the various sections of a typical patent application specification. This slide covers the Cross-Reference to Related Applications section. This section may reference applications to which domestic benefit or foreign priority is claimed, but other related applications may be mentioned here as well. For applications filed on or after September 16, 2012, any benefit claim must be set forth in the ADS, regardless whether there is a cross-reference in the specification. In view of lengthy data listings being submitted as part of the disclosure in some patent applications, the USPTO has established procedures for the presentation of large tables, computer program listings, and biotechnology sequence listings, 37 CFR 1.821, paragraph C, in electronic form. Such listings are often several hundred pages or more in length. While background and brief summary of the invention are not required, there are form paragraphs the examiner can use to suggest them to an applicant. A patent application without drawings is rare, but permissible if no drawing is necessary for an understanding of the invention. However, if drawings are present, then the specification must provide a brief but clear and accurate description of the drawings. The detailed description should use full, clear, concise, and exact terms, and provide sufficient detail to distinguish the invention from other inventions. The detailed description must be made with such particularity as to enable any person skilled in the pertinent art or science to make and use the invention without involving extensive experimentation. Practically all inventions, except compositions of matter or processes, require drawings in order for the reader to understand the invention. Requirements for drawings are found in MPEP, section 608.02. Drawings are normally black and white, but color drawings and photographs can be accepted after grant a petition explaining why they are the only practical medium for illustrating the claimed invention. When drawings are required, then all claimed features and other structural details described in the specification that are essential for an understanding of the invention must be shown in the drawings. If examiners do not find claimed features or essential structural details in the drawings, then they should object to the drawings and identify what is missing. The drawings must contain as many views as necessary to show the invention. This may include, for example, exploded views, partial views, sectional views, alternate positions, and separate views of modified forms of construction. Each part must have a unique reference number that is used consistently throughout the specification. If a reference number is mentioned in the specification, then it must appear in the drawings. Likewise, if a reference number is shown in the drawings, then it must be mentioned in the specification. Working models are not required and are not generally admitted in patent applications today. As mentioned, at least one claim is required for a non-provisional application. The claims define the scope of patent protection sought. Claims must begin on a separate page from the rest of the disclosure. This slide and the next provide information on form paragraphs to be used when objecting to claims. The original numbering of the claims must be preserved throughout the prosecution. When claims are canceled, the remaining claims must not be renumbered. When claims are added, they must be numbered by the applicant consecutively, beginning with the number next following the highest numbered claim previously presented, whether entered or not. When the application is ready for allowance, the examiner, if necessary, will renumber the claims consecutively in the order in which they appear or in such order as may have been requested by applicant.
See MPEP Section 608.01, paragraph N, for examples of proper and improper multiple dependent claim wording. You should now be more familiar with the basic requirements to file a patent application, formal requirements of the application, and how to address informalities as an examiner.